Hello friends, how are you? Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. In today's class, we will study section 49 of BNS. The topic is quite important because in nowadays, CBI or Anti-Corruption Bureau is going to use the said section as a tool so that a private person could be implicated on ground that he has abetted the commission of an offense. So basically, we have to understand the concept of section 49 of BNS. And apart from that, we will understand the strategy of prosecution regarding the application of section 49 of BNS. And if we are defending the case, we have to understand the policy of defense also, which is usually called the defense mechanism. I request all of you to maintain a proper notebook with pen or pencil so that you could maintain your information in the proper way. So first of all, we have to understand certain key points about section 49 of BNS. It basically provides punishment for the abetment. It simply says punishment of abetment if the act abetted is committed in consequence and where no express provision is made for its punishment. As we know that previously we were having IPC and now it has been replaced with BNS. Even under IPC it was an offence as defined as per section 109 of IPC, but now it is defined in section 49 of BNS. The provision simply says whoever abet any offence shall, if the act abetted is committed in consequence of abetment and no express provision is made by the Sanhita for the punishment of such abetment, be punished with punishment for that offence. And apart from that, we must note that the abetment might be by the way of instigation, it might be in pursuance of conspiracy, and it might be in consequence of help. So basically there are three modes by which the abetment could be committed, or there might be a recovery from him concerning the illegal gratification. But if there is evidence on the record that certain person has abetted the offence, in that scenario the person so abetted could be made responsible as per section 49 of BNS. And the same can be done in many ways. For example, he is helping the public servant to handle the money. He is helping the public servant in communication process. So basically, if the offence of abetment is committed by a said person in that scenario along with public servant, the abettor could be prosecuted and could be punished. And in nutshell, we could specify that if the alleged corruption means the offence is done, section 49 of BNS is inter alia invoked to punish the alleged abettor with the same punishment as provided for the public servant. Basically, section 49 of BNS is going to be used as a tool, as I told you earlier. So basically, we have to understand the strategy of prosecution also. Basically, whenever a case is on the weaker side, usually prosecution use section 49 of BNS as a tool or as a catalyst so that the concerned accused persons could be charge sheeted. So basically, in the general way, on omnibus allegations, the consent section is inter alia applied to prosecute the concerned public servant and the concerned abettor. So basically, whenever there is a charge sheet, we have to see that what evidences are on the record by the virtue of which the prosecution will sustain the factum of section 49 of BNS. So we have to see that the prosecution must prove that there is clear abetment, means there is instigation or conspiracy or there is aid in the intentional way. Mere abetment, mere introduction, mere help cannot be a scenario for application of section 49 of BNS. And apart from that, the mens rea is must. If there is no mens rea in that scenario, the accused could have the benefit, and apart from that, the link must be direct. If there is no specification, the allegations are general. So in the omnibus way, section 49 of BNS could not be applied. Now I am coming on defense side. If you are going to contest the charges of section 49 of BNS, what we are required to do? First of all, we have to show that there is no demand on the part of public servant, means the offence of demand is not committed by the public servant. So if the main offence is not committed in that scenario, the abetment would not be applicable. So simply we could say that the main offence fail, the charge of abetment would also fail. You got my point now? So basically we have to specify that the main accused has not demanded, even he has not accepted, and even there is no inducement regarding the same, and apart from that, no benefit has been derived by the main accused from your side. So basically, you are going to help the concerned accused, means the main accused, to commit the crime, but there is no instigation, there is no help, there is no conspiracy from your side, then you could have the benefit. Mere presence, mere silence is not abatement. So basically, there might be a scenario when you used to talk with a public servant and you used to sit in the office of public servant, and apart from that, there might be a casual visit. So if such scenarios occur, in that scenario, no charge of abatement could be involved in the routine way. And apart from that, the act of public servant must be committed. So if the act is not committed, the main charges are not proved. In that scenario, it could not be said that there is abatement by the other person, means by you. So in that scenario, the charge of section 49 of BNS would collapse. And apart from that, the burden is on the prosecution. There is no presumption. And if there is no specific evidence on record, in absence of which the accused could have the benefit. In addition to this, whenever we are going to contest our case, first of all, we have to read the entire charge sheet. We have to understand on what basis section 49 of BNS is entirely applied. If there is no justification, there is no evidence, there is no linking evidence, in that scenario, we could have the benefit. So there is a need to act in the peaceful way, there is a need to act in the logical way, there is a need to act in the legal way, so that we could identify our role, we could identify the facts against us, and we could easily apply the legal position and could have the benefit as per law. So I think that I have clarified you what to do if there is a charge against you concerning section 49 of BNS. See you in the next video. Till then, Jai Hind, Jai Bharat.